I don't, Sam. I'm sorry. Oh.
Good morning, everybody. Welcome to our Mapien session. Now, do forgive me. I'm hoping I can get this to a complete full screen for you shortly. This is what happens when the immigration people get let loose with PowerPoint presentations. Thank you for joining us, though. So while I'm just trying to tackle this little bit of a tech issue, we'll be taking you today through the recent changes to employer-sponsored visa frameworks that came in December last year. There's been a couple of things post-December as well that have been implemented, so we'll go through those too. Hoping that you'll find it quite a useful session. So what we're going to cover for you today changes to the 482 visa, transition from TSS to SID, changes to the subclass 186 visa. There's some really good favourable things in there for employers and employees, and a little bit about what is still to come. So before we do that, what I would like to do and begin with is just acknowledging the traditional owners of the lands on which we're all meeting today. So I'm speaking to you from Brisbane. I pay my respects to the Turrbal and Jagera peoples, the traditional custodians of the land where I'm sitting. And I also extend my respect to elders past, present and emerging of all of the lands where we're gathered today, and to the diverse communities across Australia. As we're talking through pathways and opportunities for people to move to and call Australia home, I think it's important to reflect on the deep, unbroken connection that Aboriginal and Torres Strait Islander peoples have to this land, connections that have existed for tens of thousands of years. Just as we consider new journeys and new beginnings for those coming to Australia, we honour the enduring culture, resilience and stories of the First Nations peoples, who are the first custodians of the land. We recognise their role as the first storytellers, the first navigators, and the first to shape the diverse cultural landscape that we see today. May we carry forward a spirit of respect, connection, and inclusion as we come together to discuss the opportunities ahead. So I'm joined today, presenting with me is Annalisa Simons. She's our Head of Migration in Victoria. As mentioned, I sit in Brisbane, Head of Migration on the East Coast. Annalisa and I have worked together previously and always focused on employer-sponsored visas. So hopefully we can share some really good insights with you as we move through. Please feel free to add any questions to the chat box. We'll have time at the end for some Q&A. So if anything comes to mind as we're going through, just add them in and you know, we'll try to get to everything for you. I have a helper who's arrived, so we're going to go full screen in a second. Just bear with me. This is Sarah, my saviour. Lovely. Thank you so much. All right, so let's get started. From Shakespeare, a rose by any other name, but let's go with a 482 by any other name. So there was a lot of hype leading up to the change that was made to the 482 program. It came out as a result of, you know, the major review that the current government did to look at how is our skilled sponsored framework working? How can we get maximum benefit from the programs that are supporting Australian business, and also removing what had been a concern about this emerging cohort of permanent temporary residents in Australia. So if you recall, under the previous framework, the TSS visa, individuals who had an occupation on the short-term stream weren't eligible to apply for employer-nominated permanent residence, and they had quite restricted options outside of that employer framework. If they were lucky, they could look at a general skilled visa, potentially a regional visa, but anyone employed on a short-term occupation in a metropolitan area just would have to hopefully be able to renew their temporary ones, 2 or 3 times, but that also had limits. But I'm saying it's a 482 by any other name because some of the changes did cause me a little bit of amusement in that we've gone from 3 occupation lists to 3 streams. So there's still essentially 3 options available, although they're much more generous. We have a single occupation list that applies to the core skills stream that has around 480 occupations on it. No occupation list for the specialist skills stream, some limitations, but if there's a salary that's 135,000 or above, you should be able to nominate someone under that specialist skills. What else do we have? We've gone to a 4-year stay period across any stream. It was 2 years for short-term occupations previously, 4 years for medium-term and regional. We've got a single payment structure, so probably that can be beneficial. You've got no surprises. It has been set in line with the previous charges for medium term, which were the higher of the 2, but it does reflect that everybody gets a 4-year stay. So that's the rationale there. Labour market testing, haven't had any changes yet. We'll look at that a bit later in our still to come. Income thresholds, one thing that the department had indicated would come in, which is tiered income thresholds across the streams. So core skills currently is 73,150, specialist skills is the 135, as I mentioned. And these income thresholds will become subject to annual indexation. So 1st of July will be our first increase. 2 years work experience used to be required under the TSS, but it's now been reduced to 1, at least 1 in the most recent 5 years, and it can include a combination of full-time, part-time or casual. Previously, it was only full-time and prorated part-time. I'll talk to that a little bit more in a few minutes. And standardized English language requirements, which is really helpful. So now we have to both streams have to meet the same minimum standard, which is competent, which is, as an example, if they were to sit an IELTS test, it would be an overall score of 5 and a minimum of 5 in each of the components. Temporary skill shortage visa, employers have always had to demonstrate and evidence that it's a genuine position within their business. That's still there. There's probably a higher level of scrutiny on there, particularly for smaller to medium businesses, or it might be an occupation that a business hasn't tried to access before. So it could be that you're expanding into a new service offering or market. So, it's probably wise to give some context to the department if that's occurring. But what has come in is an increase also on the department being satisfied that a business has the financial capacity to offer the employment. And that may be due to the higher salary threshold that's applied to the specialist skills. If you're offering a high salary, can you actually afford to pay that to the person over the, forward 2, 3, 4 years that you're asking for as a stay period? So if we go into that in a little more detail, changes for nomination applications, what we've seen is core skills stream. So that's probably fairly self-explanatory. Any occupation that fits on the core skills occupation list can be nominated under this stream. The salary is well, essentially this is for occupations that have a salary that sits between 73,150 and up to 135. Interestingly, though, if you have a very highly skilled tradesperson who's going to be earning over 135,000 per annum, their visa approval will default to core skills. So you're not allowed to nominate a tradesperson under specialist skills. I'm not sure why, but the department's excluded trade occupations from that category. Core skills, you can nominate up to 4 years. You may want to think about whether you need the 4 years. There is an increase in interest on permanent residence for people now. So some individuals after 2 years on a 482, they'll be eligible to seek a permanent application. So you might only look at doing a 3-year nomination for people under any of the streams. For core skills, occupations on the core skills list are eligible for permanent employer nomination under the direct entry stream. Annalisa will talk to that in a little while when we move on to the permanent program. But just to note that the direct entry stream is exclusive to core skills occupations. It's not open for everybody. Then we go to specialist skills. And this one I was very surprised by because I've been doing this for a very long time now. My registration was approved just yesterday for the 20th year. And when this was first speculated, I was thinking there would be really no way that the government would be this flexible to allow business in Australia to nominate any occupation, some parameters, but any occupation provided the salary was over a certain level. It's like, how can that happen? But it happened. So there you go. Lesson learned. Life is full of surprises. So it's good. It's been a really good change. So what you have to satisfy for this stream is that the occupation or the position that you nominate, it has to align with an occupation that's listed in ANSCO, which is the Australia New Zealand Standard Classification of Occupations, published by ABS. And it has to be in major groups 1, 2, 4, or 5. So trade occupations, as I mentioned, are excluded from this stream, but most trade occupations sit within level 3. Minimum salary of 135,000. And again, there's up to 4 years available here, but there may be times when you might only need 2 years. It could be 3, could be up to 4, depending on what the longer term strategy is in relation to retaining that person. You could have had conversations with them from the outset about them having an interest in permanent residence. They could have been on shore for a time already. They could be close to qualifying. So it may be that you only need a 1-year visa for them or a nomination transfer to get them onto your payroll to then look at taking that forward. As I mentioned, the income thresholds will be subject to annual indexation going forward. So it's the Australian ordinary time earnings that I think will be used as the indexation method going forward. So from 1 July this year, the core skills stream, the minimum salary will go up to 76,515, and the specialist skills, the minimum salary to qualify will go up to 141,210. This could become problematic, I suppose, because there may be occupations, industries over time where the increases themselves will knock out certain occupations. There's just no reasonable way that an Australian business could offer a higher salary than what's being offered to Australian workers in the same role. So in those cases, not all is lost. That's when we get to the labour agreement stream. So if you have occupations that aren't eligible for sponsorship currently under the standard business arrangements, you can look at then applying to the department for approval for a labour agreement. So we have 5 different types of labour agreements currently available. There is company-specific labour agreements. They do take quite a bit of work, but they're very useful once they get approved. They're valid for 5 years, and you request access from the department to certain occupations, and that's where you can also request an exemption to salary levels, minimum salary levels, and you would be benchmarking against perhaps an award, an enterprise agreement, or just the general salary rate in Australia. There are DAMAs, which are designated area migration agreements. So they tend to cover a whole lot of regional areas in Australia, and each DAMA may have its own occupation list that applies. They can also be very helpful. And when these are approved, DAMAs, for example, give you access to 482 sponsorship, but also 494 regional sponsorship. And the 494 can sometimes be more favourable for people as well, depending on their age. Global Talent Employer Sponsored, the department's still got this listed, but the Global Talent Visa in its previous form is no longer around. It's now the National Innovation Visa. We're not going to talk to that one for now, but I've just still got it in there because the department's still listing it, and there would be existing agreements still going on that one. We have industry-specific labour agreements and then also project agreements. Now, industry agreements, currently there's 10. Advertising, they're all listed here: advertising, aged care, dairy, fishing, horticulture, meat, minister of religion, on hire, pork, and restaurant premium dining. So the restaurant labour agreement, we've seen an interest in, an increase in interest, because cafe and restaurant managers came off the core skills occupation, aren't included on the core skills occupation list. And while, you know, premium dining, you would expect a higher salary to apply, there may not be many premium dining restaurants that offer a salary above 135,000 for their restaurant managers. So in those cases, it's, you know, going towards the labour agreement stream. So you can still access them, but just maybe not through traditional pathways. And then common requirements for nominations. The common requirements haven't really changed. That's all still the same as it was. Labour market testing still needs to occur unless you have exemptions available. Generally, we've got exemptions for international trade obligations. If the person you're wanting to sponsor holds a passport from certain countries, UK, Canada, there's a few others in there: Japan, Thailand, I think, Chile, and a few others. But anyway, if you've got the ITO in place, you have an exemption to labour market testing. Intra-company transfers will also provide an exemption, higher salaries, and if you've got someone employed in the occupation where they've worked in that position for at least 2 years already, you can also have an exemption to labour market testing. We love it when you get an exemption. Makes everybody's life easier. You have to engage your nominee as a direct employee, so that hasn't changed. There needs to be that direct relationship. Immigration wants to see that the approved sponsor is responsible for the employment of the person. You can sponsor someone to work for an associated entity. That has to be, you know, meet the definition of associated entity that's in the Corporations Act. Or if you're engaged in on-hire, labour hire, you could seek an on-hire labour agreement that would allow you to then hire that person out to a completely unrelated business. Skilling Australians Fund levy. People who already use the program will be very familiar with this, but the SAF levy, as it's referred to, is collected at time of application for an employer nomination under the SID visa, and it's charged at a different rate depending on turnover. So it will either be $1,200 for each year of stay that you request, or $1,800 for each year of stay that you request. It ticks over to $1,800 if revenue is 10 million or more. So if you're nominating someone for a 4-year stay, that's $7,200 that's collected by the department. It is used for training, or the intended use is to provide training opportunities and fund training programs for Australian citizens and permanent residents. There's not a lot of oversight on how it's been used since it was introduced. Some people are concerned about that. Where is it going? But it is what it is, and an unavoidable cost that you need to pay. One thing to note is, as a business, if you do pay the SAF levy, you can treat it as a tax deductible expense with the ATO. Genuine position, that's always been in place, so the department needs to be satisfied. As I mentioned, that the role is genuinely needed by the business, so they just want to see, where does it fit? What do you do? Why do you need this particular position? We don't have a lot of issue with that. If there's any concern, or we feel the department might have a concern, then we'll include a submission to just connect the dots and, you know, allow that favourable decision to come through. Changes for visa applications. So not a whole lot, but, you know, certainly some good ones. So Work experience, as I mentioned, that's gone down to needing only 12 months in the most recent 5 years. Obviously, the more experience someone has, the better. One thing that we've noticed is that the department is starting to look at the work experience very carefully. So it may be that they've realised they've become a little bit too flexible, and there have been requests for further information now being issued just for, proof of work experience beyond that 12-month period, and also proof that it has been paid work experience. So I'd just be mindful that, for anyone who's sitting at, maybe only 12 months, we just need to be sure that the department's satisfied that they're highly skilled. ANSCO itself might apply a higher work experience requirement. So if that applies, then that's what needs to be met. So you also need to be careful that, what does ANSCO need? Can they meet that? Don't just think it's only 12 months and off we go. It may not work for every particular occupation. As I mentioned, it can be combined full-time, part-time, or casual employment. But if it's part-time or casual or a combination, we still need to make sure that it pro-ratas to at least 12 months full-time equivalent. Relevant experience has also been expanded a little bit. It used to be that you had to have experience in the occupation or a closely related occupation. It now says occupation closely related or related, but again, I'd apply caution here because of the higher level of scrutiny that's starting to apply. English language requirements, as mentioned, that's just been standardised, which makes it a lot easier to advise people. Previous exemptions are still in place, so 5 magic passports, as I call them: Canada, UK, US, New Zealand and Ireland. No English needed. 5 years of full-time education where instruction was in English, high school level or above, that's all good. Intra-company transfers as well, they're the primary ones. The big change, this is the big one, is to condition 8607. So this condition is applied to every primary sponsored 482 visa when it's approved. And prior to 7 December, individuals would have a period of up to 60 days after ceasing employment to apply for another visa, depart Australia, or have a nomination lodged by another employer. And if they didn't do one of those 3 things within that period, then they'd technically be in breach of their visa condition. And they weren't allowed to work for another employer until that new nomination was approved. So what's happened now is if somebody ceases employment with their sponsor, they have up to 180 days from the last day of employment to depart Australia, apply for another visa, or in most cases be nominated by a new employer. But they can work for anyone during that time frame. So they don't need a new sponsorship approved to start with a new employer. They can work in any position. They're not restricted to what they're approved to work in anymore. And they can work full-time, part-time, casual, could take up 2 jobs if they wanted to. But after the 180 days, that needs to stop. So for the most part, I think people will be focusing on finding a new sponsor, but it does allow people to be able to continue working and, paying rent, buying groceries, maintaining a life in Australia while they're seeking new employment. So very favourable for visa applicants. I think the previous 60 days and not being able to work was causing, some reasonable problems for people. It can be accessed, this flexibility, just for a maximum of 365 days or 1 year for the entire visa period. So they could have 2 breaks in employment, or maybe 3, 4, who knows. So long as the total period doesn't exceed 12 months, they'll be fine. So that's probably the main one. I've already touched on the pathways to PR, so I won't go through those again. But what to consider, just a couple of little tips or, considerations before I hand over to Annalisa. So as I mentioned, have a think about how long you should nominate someone for, given the flexibility on the 482, but also some flexibility on the 186 that Annalisa will talk to as well. It may be that, you've got someone approaching you for for a role, they come on board, they've already said to you, look, I really want to get permanent residence. I've been here for 2 years already. Will you support me? In that case, just have a think. Do you have to pay 3 years SAF levy for a 482 if they're going to apply for a 186 within the first 12 months? So it's just saves a little bit of money. Everybody likes to save a little bit of money. So I wouldn't by default go for a 2, 3, 4 year stay period if you can reasonably avoid it. Recruitment and retention. The flip side of the flexibility of the employment condition is we are seeing 482 visa holders start to move a little more. You know, they're not as worried about, you know, well, I can't leave this job. I'm not really happy here. I've only got 60 days. It's too hard. I'm just going to hang out until I can find something else. They might just say, well, I've got 6 months to find something else. I'll just go and work in this job while I'm looking for a new sponsor. So that is happening. It will happen. So just have a think, I suppose, about, you know, what are your recruitment strategies looking for? Are you doing any kind of testing or screening for their job fit? How do they cope with change? How do they deal with stress? Because outside of starting a new job, particularly if they're arriving from overseas, there are added stresses on a completely new country, a new way of working, a different, you know, the way we work in Australia may be a little bit different to what they're used to in their home country. So you've got to factor in they're going to have extra challenges than your locally engaged workforce. You know, can you buddy them up with someone, not just for a couple of weeks, but for the first 12 months? Can you connect them with cultural associations and communities to help that integration? Trailing spouses, you know, that can often be a point of failure if they've got family with them and the family feel isolated. So just really trying very hard to help them settle in will save a lot of, I guess, angst for that employee. You want them to succeed and you want their families to be happy as well. Labour market testing, this can cause delays. You know, you run an ad for 28 days, you screen the candidates, you find someone, you make an offer. We get to nomination stage and those ads have expired and you have to start again. So I think if you've got hard to fill roles or multiple vacancies, just keep them open for longer. You know, even up to 3 months can be helpful. Contracts, you might have offered a contract already and then you have to re-advertise, then you have to offer another contract because it has to be dated after the advertising. So keep that in mind as a little administrative headache. And just a final quick note on the processing times. So when this came in, the department initially suggested 7 days for specialist skills. Fantastic. And 21 days for core skills. It did work for a little while, but there's been such an influx of applications. Apparently, at a recent conference, the department shared 3,000 plus a week are currently being received under skills in demand. So there is a backlog building. So at the moment, it's between 13 and 38 days for specialist skills. And oh, that update hasn't changed. Sorry, it's I think between 36 and 64 days for core skills. And the department would be unlikely to expedite unless something was extremely urgent. So just keep in mind, these are the timeframes that are currently being applied. Now, that's all from me. I'm going to hand over to my colleague Annalisa, who can take you through the 186 permanent changes and a few things to consider there as well.
Thank you, Sam. Yes, so recently there have been considerable changes also in relation to the employer nomination scheme, the subclass 186 visa. Effectively, these changes have expanded the pathways to PR for employer-sponsored visas and increased, at the same time, the mobility of employer-sponsored visa holders, also in light of some abuses that have happened in the last few years. So the aim was clearly to decrease the number of what they called permanent temporary residents, that is, people who've been in Australia for an extended amount of time on temporary visas, as they seem to form this increasing cohort of permanent temporary visa holders. So the government has made attaining permanent residence easier, and what I'm about to describe are the main changes. So as you will remember, the streams for the employer nomination scheme, the subclass 186, leaving aside the labour agreement stream, are the direct entry stream and the temporary residence transition stream. There are common threshold criteria for both streams. For the nominating business, they're still the same. So the business has to be actively and lawfully operating a business in Australia. There has to be no adverse information about the business, and this goes beyond immigration compliance history. It refers to contravention of laws in general. And the business must have, very importantly, the financial capacity to offer employment for at least 2 years to the applicant. So that's where your financials and the scrutiny of your financials will come into place. With regards to the nominated position, the common criteria to the two streams, again, are still the same. So there must be a genuine position, and the business must be able to demonstrate a genuine need for the talent. Let's not forget that these visas are given to Australian employers because they need foreign talent on a permanent basis. Additionally, nominees must attract a salary that aligns with market rate. So employers cannot think that this is just a way to pay a foreigner less than what they would be paying in Australia. And the market rate needs to be obviously in addition to being above the threshold that Sam was referring to with the core skills income threshold, which is now 73,150 and will become 76,515 from the 1st of July. There needs to be a full-time role in Australia for a permanent residence visa, therefore 38 hours per week, or a period between 32 and 45 hours per week specified under an award or agreement, an industry award or agreement, consistent with the national employment standards. So if we just concentrate on the direct entry stream, you may remember that under the direct entry stream, we've got applicants who may be untested by the Australia labour market. They don't need to have been on a 482 visa. They don't need to have worked here. So the changes relate to, one, a bigger list, the core skills occupation list that Sam mentioned, with 456 occupations in total, where the focus is mainly on health, education, engineering, cybersecurity, IT. The direct entry stream, as it was before, still requires 3 years of post-qualification evidence, full-time employment experience, and there are exemptions for academics, scientists, importantly, New Zealand citizens, and they need to be employed in the occupation for 2 years. It's not 3 for New Zealanders. Applicants need to have a positive skills assessment in the nominated occupation. The salary, as we said before, needs to be in line with market rate and above the minimum threshold, but this amount will be indexed on a yearly basis. So this is very important to consider. And finally, applicants must be less than 45 at the time of application. Once they turn 45, the direct entry stream is not open to them unless they are part of one of the exemptions that relate to senior academics nominated by an Australian university, scientists, researchers nominated by government scientific agencies, the New Zealand citizens that I was referring to before who've been employed for 2 years by the nominating employer, and of course all applicants must demonstrate competent English, health and character, which are not as usual as it was before. With regards to the temporary residence transition stream, applicants instead here must hold a 482. But the change is that there is no list applying anymore. The nominated position must correspond to an occupation listed in ANSCO, and it must be the occupation of the most recent 482. So applicants must have been sponsored on the 482 by the same business, which is the nominating, the 186, the ENS nominating business. And they must be working in the same occupation as their current 482 visa. Now, the big change, and this goes back to what I was saying before about making it easier to obtain PR, is that applicants now need to be employed not for three years on a 482, but for 2. So 2 years in the last 3 on a 482, It used to be 3 years in the last 4. And another big change is that changes in employer or in occupation no longer will restart the qualifying employment period of these 2 years. During these changes, visa holders must be the primary visa holder. They can't have become secondary visa holder because maybe their partner has become the primary visa holder for one of the 482 visas. But importantly, if 186 applicants have changed employers in these 3 years, any sponsored employer can be counted from the date that a 482 nomination was lodged, not necessarily approved. If then they continue to work for the nominated entity, and of course, this is in the case that they started working with them before the 482 nomination was approved. Similarly to the direct entry stream, they need to be less than 45 at the time of application, unless there are exemptions. And exemptions in this case apply to, like in the direct entry stream, academic and scientists, medical practitioners who've worked in regional areas, apologies, for at least 2 years, high income earners, and the high income threshold is now 175, so 2 years earning above 175,000, and obviously they still need to demonstrate competent English, or unless they hold one of the magic passports that Sam was referring to. So that was a very brief summary of what the changes entails. But if you just want to retain what to consider, it is important to appreciate that I'm sure all of you would have received multiple requests to go to PR as soon as possible, because this is normally the ultimate aim for visa holders. So when would you want to support an application for PR? Well, one consideration to be had is that the costs for an ENS application and the costs for a 482 applications are very similar. So you might think, could I go straight to a 186 visa instead of spending the money for the 482, particularly if you have already tested the skills of this person under different visas. The thing to consider is that because before, particularly under the transitional resident stream, applicants needed to spend a certain amount of time working for their employer in order to qualify, and now instead time under any employer will qualify. This incentive to remain on a 482 with the same employer is no longer there. So if anything, as Sam was saying before, it can be quite quick to obtain a 482 and then for them to go to a different sponsor. But a 186 visa can take between 13 and 18 months. And they, particularly if they're already working for you, they need to remain working for you until the visa is actually granted. So it can become an incentive for you to retain them for a longer period instead of having them moving among different sponsors for the 482 if you apply for a 186 application. A further consideration can be the fact that, as we said, the thresholds will be indexed on a yearly basis. So some position may not meet the minimum standard going forward. So you might want to get in before the change of the next year is actually implemented, because it can become the salary may become too high. Another consideration is the fact that there might be a greater ability to offset costs, in the sense that with a 482 visa, you've got sponsorship obligations and you can't bear any costs relating to the nomination, including the professional costs of any immigration professional that assisted you. Whereas with an ENS application, all you need to cover are the lodgement fees for the ENS and the SAF, which can be 3,000 or 5,000, but every other cost can be paid by the applicant. So that's, another way to save money. Another thing to consider is that LMT is not required for a 186 application. So if LMT can create problems to your processes and employing someone, then you might want to consider the 186 in this sense. Having said that, evidence of LMT may go towards evidencing the genuineness of a particular role or position. So I would always suggest to have LMT ready, because that can always be beneficial. As I was saying before, you should consider, though, depending on the circumstances, the processing times, because these have really expanded lately, and they go from 13 to 18 months for direct entry and from 14 to 18 months for temporary residence transition. So, you know, if they're not already working for you, the 186 straight away might not be the best option. And then if we can move to the next slide relating to what's still to come, as we said, various time, the threshold will be yearly indexed. So from the 1st of July this year, the core skills income threshold will increase from 73,150 to 76,515. And with regards to the specialist stream, it will increase from 135 to 141,210. So they are significant increases. One positive one, which hasn't been implemented yet, and we'll see if the elections will change some of this. Labour market testing might be expanded in terms of validity period from 4 to 6 months, but we haven't seen any of this yet. The government had similarly announced the publication of a register of approved sponsors for 482, but we haven't seen anything yet. And another thing to consider, I suppose, if there was to be a change in government, at the moment, the permanent migration levels are around 185,000. These are normally the 185, 190, the standard numbers. But if there is a change in government, the coalition has proposed 140,000, which means that there may be longer processing times again in relation to ENS visas if Mr. Dutton wins the elections. I don't know, Sam, if you wanted to add something.
Yeah, I think it's just, in context of that is, I think the department's on track from what I've heard to meet the program levels this year, like to use the full amount of places available. And when that happens, it's never really published that they've officially met the target, but each year when it happens, processing stops on permanent applications, but they're still accepted. So if we meet, let's say we get to mid-May, 185 places have been taken up, applications can still be lodged, but they're just joining the queue and they're joining the queue. And the department can't start approving anything again until the 1st of July. So it's happened a couple of times through, the time that I've been doing this for, and it really does, have a big impact. You wouldn't think it would. And probably good for people to be aware as well that the 185,000 places, it's not primary applicants only, that's family members as well. So it's not like, 185,000 primary skilled applicants that are being approved, and it also includes, family places. So it can fill up quite quickly given the high demand that's out there. So I guess we'll wait and see how that happens. But I think overall that will mean processing will slow. They might stagger the amount of approvals across the year. It might be, that they just steam through and approve, and then again we have another backlog building up. So I think there's a lot of economic analysis of that level of cut not being wise for the economy, given, people aren't having as many children, people aren't moving into some of the roles where the big gaps are. So it may be that it doesn't happen. It could just be, a nice election pitch, because migrants are often, painted with a not so friendly brush when we're looking at an election coming up, but time will tell. So I guess that brings us then, I might stop this share just so we can come to screen for you, but it brings us to questions. So I've just opened up my little question box here. So, and I've had a couple come through in advance, but if anyone's got additional questions, just throw them in here for us and we'll try to answer them for you. So someone has asked, can any employer sponsor 482 or 186 direct stream, or are there any requirements to be eligible to sponsor a visa? Can you share these as well? I think sponsorship for the 482 and also the 186 isn't restricted by business size. There are criteria to be met for sponsors. You don't need to hold standard business sponsorship under the 482 program to nominate someone for a 186 visa either. That's probably good to know. So if, for example, you hire a skilled graduate, they're on a 485 visa that has full work rights, they've got 3 years work experience. For the 186, work experience can be at any time. It doesn't have to be within the last, 1 year in the last 5. So you could consider, okay, this graduate is really great. They've got all of the skills I need. I want to keep them. Bearing in mind a 485 visa has, a validity anywhere from 2, 3 to 5 years. So they could be working for you for a couple of years and you're ready to make the jump. You don't have to put them to a 482, so long as they meet the 186 requirements. They need a skills assessment, 3 years experience. 482, small, medium, large businesses are fine. The main thing is actively and lawfully operating a business, genuine need for the position, and financial capacity to pay. But startup businesses can access a 482. So, it's just a matter of, when we're looking at it for a business, we need to be comfortable that you're going to meet the requirements. If you're a startup, there's extra documentation, a lot of care goes into preparing those applications, but they can be approved. So I don't think anyone should be automatically think they won't qualify because their business might be smaller or they haven't sponsored people before. Charmaine's just asked if we can share the presentation. We definitely will, Charmaine. It'll be sent around after. And then if you've got any other questions off the slides, just get in touch with Annalisa or I. Okay, if this was already said, wondering if the applicant is paid over 135k base, that they do not need to match an occupation on the skills list. Annalisa?
Yeah, that's correct. Remember that it's going to go up to 141 from the 1st of July, but that's correct. No list applies for the specialist stream of the 482. This was very much to respond to the competition that Australia is in with Canada, the US, the UK, the more advanced economies for foreign talent. So they thought that the fact that there was a list, as there was before the skills and demand visa, was possibly very rigid. It's very hard to change ANSCO. It takes time. There are these new technology occupations that keep coming up very, very fast. And therefore they thought, well, if we really want to attract the main talent that is around, we need to be more flexible. And so they thought, if we set a high income threshold, then we may be able to get away with the requirement of the list. The list is too rigid. Obviously, it will be, as Sam was saying before, unfortunately, this is in relation to more skilled occupations, not trades people and not laborers. And that we will see whether the department will scrutinize them. But of course, if you've got a highly skilled role and a salary above 145/141 from 1st of July, you will not need to comply with any list.
Yeah, they do still need to be it still needs to match an occupation in ANSCO though, although pretty much every occupation you could possibly think of should appear in ANSCO. It just needs to be at that skill level 1, 2, 4, or 5. But that's very broad. I'd be surprised if you were looking at an occupation attracting that kind of salary if it weren't in there somewhere. So then we've got another question on 482. So existing 482 visa under the previous TSS, do they need to apply for an extension before applying for the 186, or are there any exceptions? That's fine. You don't need to renew. 186, it can be you just need to hold the primary sponsored 482. It doesn't matter if it was under TSS or under SID. And you'd only need to renew if, so the previous short-term visas were granted for 2 years. So this is where sometimes there have been unnecessary renewals just to allow someone to apply for a 186, because as Annalisa mentioned, you need to have worked full-time for at least 2 years while holding that primary 482 visa. But that doesn't include periods of unpaid leave. So for people in Australia, when the 482 is granted, the qualifying period starts from the date of grant. So, and then if they're on a 2-year TSS, they've only got 2 years. The department introduced some flexibility to avoid an unnecessary renewal that would allow you to submit a 186 application no more than 5 days prior to meeting the 2-year requirement, where you've got a 482 that's going to expire. So they've recognised that, you know, making you apply for another 2-year 482 or a 1-year 482 purely for 1 day to then lodge a 186 wasn't very fair. So nice to see the department being fair in policy. The only time you would have to renew if you were on a short-term TSS is if you've had unpaid leave for greater than that sort of 3 to 5 days. So somewhere in your 2 years, you've had a month off without pay, you'd have to renew and get another 482 to then lodge the 186. So hopefully that makes sense. Okay, Annalisa, with the processing times, we have an employee on a working holiday visa. Do we need to have the 482 approved by the end of the working holiday, or just lodge it before the expiry?
So with working holiday visas, you generally, unless an exemption applies, can only employ a working holiday visa holder for 6 months, but their visa will probably be it's normally for a year, apart from now the cases where they can be up to 3. So it's normally before the end of the 6 months that you want to apply for another visa, the 482, and ask the department. There is a form, a specific form, where you ask the department if they can lift this 6 months condition. If the visa, as I said, the visa can be for one, it's normally for a year. If they are close to the end of the year, once you lodge the 482 and once the bridging visa that comes from the 482 becomes into effect, on that bridging visa, they would have another 6 months. So it really depends on the timing as to whether you would have to ask the department to lift this 8547 condition or not. So in other words, let's say someone has a yearly visa and they are coming to work for you in the first 6 months of this yearly visa. Before the end of the 6 months, you would ask the department to lift their condition. If it was at the end of the 6 months and you lodge the 482, and soon they would get onto the bridging visa, if they had not completed the 6 months, you would then have the benefit of having another 6 months on their bridging visa. I hope that makes sense.
Yeah, I think so. There's a couple of automatic exemptions as well if the person, like for people working in particular sectors and areas in Australia, they can be taken to have an extension to that 6 months. But yeah, 482 applicants, the department will pretty much take it as standard that they'll give you an extension to the work rights, but you still have to submit the request and the application has to be lodged ahead. There's another question about applying for a 186 from a 482. When does the 2-year eligibility start? So quick answer for that one, it starts from when the 482 is approved, not from when the 482 is lodged. So the qualifying employment for that 2 years for a temporary residence transition stream has to be while holding a primary sponsored 482.
And working for the sponsor in Australia.
Definitely. Yeah.
So if they're offshore and they come after 2 years from grant, 2 months from grant, those 2 months
Yeah.
qualify. Yeah.
Very good point. Yes, we'll share the slides. Okay, for temporary residence transition visa 186 for over 45s on core skills, do they only have to meet the threshold of 73, etc., not the high income threshold if they're applying off a 482?
Me?
Yeah.
So if they are above 45 and they want to apply for a 186 TRT, they will need to earn above 175,000 for each of the 2 years on the 482. They will qualify them for the 186.
Yeah. If you've got someone over 45 on a 482, you know, there could be other visa options as well, or there could be potentially a labour agreement. So the 482, I guess, is the primary visa that people think about, but, you know, we can help with just looking at what other options might be out there for people, because there will be over 45s who aren't going to meet that threshold. There's not masses of occupations, but sometimes it's a matter of just, you know, having a look through and seeing where there might be an opportunity that hasn't been thought about before. For the 186, 3 years experience in Australia, it's only 2 years for TRT stream sponsored employment, but if it's direct entry, the 3 years can be with any employer in any country, so long as it's full-time post-qualification. Oh, okay, here's a good one. You might like this, Annalisa. I'm not going to talk to it because it frustrates me. Specialist roles, trades don't count. Would supervision roles within mining construction count as trades?
Well, with regards to the roles, we really have to check what ANSCO aligns with. It's very difficult to just give you, you know, a generic answer in this sense. The fact that they may have a more managerial role within their occupation does not necessarily change the occupation. So it would be a matter of checking what the position description is like, what occupation on the list it aligns with, and then see if we can have, if they are actually tradespeople or whether they are managers.
That's right. So I think we're almost up to our time. There's a couple of other questions in here, but they're sort of similar to the ones we've had just on the qualifying period for 482s, moving to 186. Onshore people, it starts from when the visa is granted. Offshore people, it starts from when they start working in Australia. Okay, last one I think we've got a quick time for. Working holiday visa holders, if after 6 months they are employed by an associated entity, does the new 6-month period start again, or is the first 6 months counted as continued service? I think that you have to be really careful of, because the department will look at who is the end user. So a background contractual change won't give you another 6 months if they're still working in the same position with the first entity. They have to be doing a completely new job with the associated entity. But one thing, if they go from working in the office to working from home, they can have another 6 months. So that was another surprising bit of flexibility from the department brought in recently that I just was quite amazed by. Maybe catching up to the idea that people don't always work in an office environment anymore. So that's probably a handy one to keep in mind if it's a job that, you know, you can put someone into in a remote thing.
So if I may, Sam,
Yeah.
so it's 6 months with each employer at each location. If you keep these 3 in mind, that might be useful.
Yeah.
So if they change location with the new associated entities, it's a different restaurant, let's say, but it would be fine.
Yeah. And last one, around 45 years, will that be looked at? Look, it's a good question. I'm over 45. I very saddened by the fact that we've got a cohort of skilled workers who can't apply for PR because they're over 45. The age limit used to be 50. If you're over 50, we could put a submission in outlining why you should be able to have a visa beyond that age. If you're looking at healthcare, I'd say, you know, really have a look at the labour agreement options where you're employing people into that sector, because you can request age exemptions under the labour agreements. You know, you could go for company specific if there isn't an industry template to suit you. So that's worthwhile considering. But we are right on 12 o'clock. So I just wanted to say thank you again, everyone, for joining us. Forgive me for my momentary tech issues. Thank you, Annalisa, for trusting me to move your slides along after my tech issues. If anyone has any questions, though, we will share the slides. We'll share the Q&A from questions we've had. Our contact details will be on there. So more than happy to help, you know, with anything that you may need to help with sponsoring your employees, or, you know, navigating a pathway if you think there's currently some blockers there. Okay. Thank you, everybody.
Goodbye, everyone.